Assalamualaikum and good evening to Dr. Rozana. My name is Muhammad Ahtaf Mazhar Rizal and my meeting number is 208081. So my group will present about company separate legal entity and Turquand'S rules. My group is consists from 5 members, which is me, myself, Sufian Hidayat, Kashwan, Muhammad Nafilaus and Fahimul Azim. So we divide the part which me, myself, Atta, Sufian and Kashwan will present about separate legal entity, while the Turquand'S rules will be presented by Azim and Filaus. So moving on to what is a separate legal entity. Separate legal entity is a person recognized by law or known as a legal person. It has its legal rights and obligations whereby separate to those running and owning the entity. The entity has a distinct entity and independent to its member or people which can control it. The separate legal entity is regarded as a single juristic person distinct from its member who constitute the company. It can enable a company to own property and deal with the way it likes. No member of the entity, either individually or jointly, can claim the right of ownership in the asset of the company during entity existence, during or in its winding up process. Thus, a separate legal entity means that only the company is responsible to repay creditors and to get sued for its deeds and actions. The individual members cannot be sued for actions performed by the company. As saying in different terms, the company is not liable to pay personal debts of the members. So I will pass my next presentation to the next presenter. Thank you.
Thank you, Ahta. Assalamualaikum and hi, my name is Sufian Hidayat bin Saril Anwar, matrix number 205938. Now, I will be continuing the presentation on a case that is related to separate legal entity, which is the Salomon versus Salomon and Company Limited, which was also known as the one-man company. So I will start the first about the facts in Salomon versus Salomon. So Salomon transferred his business of bootmaking, initially run as a sole proprietorship, to a company, which is Salomon Limited, incorporated with members comprising of himself and his family. The price for such transfer was paid to Salomon by way of shares and debentures having a floating charge on the assets of the company. Then, when the company's business failed and it went into liquidation, Solomon's right of recovery against the debentures stood prior to the claims of unsecured creditors who would thus have recovered nothing from the liquidation proceeds. To avoid such alleged unjust exclusion, the liquidator, on behalf of the unsecured creditors, alleged that the company was essentially an agent of Solomon, and therefore Solomon, being the principal, was personally liable for its debt. In other words, the liquidator sought to overlook the separate personality of Solomon Limited Company, distinct from its member Solomon, so as to make Solomon personally liable for the company's debt as if he continued to conduct the business as a sole trader. So what are the issues in this case? So the case concerned claims of certain unsecured creditors in the liquidation process of Solomon Limited, a company in which Solomon was the majority shareholder and accordingly was thought to be made personally liable for the company's debt. Hence, the issue was whether, regardless of the separate legal identity of a company, a shareholder or controller could be held liable for its debt over and above the capital contribution, so as to expose such member to unlimited personal liability. So what are the ruling in the Solomon versus Solomon case? So the Court of Appeal declaring the company to be a miss, reason that Solomon had incorporated the company contrary to the true intent of the then Companies Act 1862, and that the latter had conducted the business as an agent of Solomon, who should therefore be responsible for the debt incurred in the course of such agency. The House of Lords, however, upon appeal, reversed the above ruling and unanimously held that as the company was duly incorporated, it is an independent person with its rights and liabilities appropriate to itself, and that the motives of those who took part in the promotion of the company are absolutely irrelevant in discussing what those rights and liabilities are. Thus, the legal fiction of corporate veil between the company and its owners was firmly created by the Solomon case. So the conclusion is the Solomon ruling remains predominant and continues to underpin English company law, while sham, facade, and fraud primarily trigger the invocation of the veil-piercing exception in limited circumstances. So these grounds are not exhaustive, and much is left to the discretion and interpretation of the courts on case-to-case basis. So that's all from me. Now I will pass to the next presenters. Thank you.
In the case of Makara versus Northern Insurance Company, initially, Makara has owned a real estate with the timber plantations. Later on, Makara has sold the real estate as well as the timber to the Makara company and received a consideration from every one of the wholly paid share. Later on, Makara company had carried out the business of felling and miling the timber plantations. Unfortunately, the fire had been destroyed the timber which have been felled off.
Makarov had earlier insured the timber against the loss of fire in his own name. He had not transferred the insurance policy to the company. So, when Makarov applied to the insurance company for the payment, the insurance company refused to pay on the ground of that Makarov did not own the timber of his name and he is not the real owner of the timber. Thus, he could not claim the payment. The decision in this case by the court of law made it very clear that property of the company is sole property of the very company, and no person had the right to interfere the company's property, and even the shareholders have not the right to use the company's property without the company's consent. The company has the right over the very property, and it is at the disposal of company either to sell or insure the very property.
Statutory exception means various exceptions under the Copyright Act that permits certain things to be done in educational institution or the person acting as an authority of an education institution that would otherwise infringe copyright. It is said that the principle of separate legal entity forms the foundation of modern company law. Any exception to this principle therefore must be seen as challenges to those foundations.
So, from the discussion above, it is concluded that the corporation is a separate legal entity, separate from its member, and a firm after its proper incorporation through the corporate law acquires a juridical status. There are certain rules and regulations regarding the shareholder and the property of the company. If any of those terms in the contract is violated by either party or both the parties has the right to approach the court. So the corporation can sue and can be sued. However, certain restrictions have been imposed to this principle in order to prevent the abuse of limited liability protection. The veil of incorporation may only be disregarded to avoid fraudulent and reckless trading or where the sole purpose of which company is incorporated is fraudulent or illegal. The court of law can disregard the corporate veil in order to ensure justice.
Assalamualaikum and hello everyone. It's my turn to present. My name is Muhammad Nur Firdaus bin Sabri with metric number 207276. I will tell you about the Turquand'S rule. Turquand'S rule, also known as the doctrine of indoor management, is an old concept which protects outsiders against the actions done by the company. Any person who enters into a contract with the company should ensure that the transaction is authorized by the Articles of Association and Memorandum of Agreement of the company. There is no requirement to look into the internal irregularities, and even if there are any irregularities, the company should be held liable since the person has acted on the grounds of good faith. An example is UK company law case between Royal British Bank versus Turquand in 1856. Turquand's rule is named after the person. Next, let's look at an example of case law in Malaysia involving Pekan Nanas Industries Sdn Bhd versus Chang Ching Chuan and others in 1998. The Pekan Nanas case concerned a dispute over the ownership of land that stemmed Next, let's look at an example of case law in Malaysia involving Pekan Nanas Industries Sdn Bhd versus Chang Ching Chuan and others in 1998. The Pekan Nanas case concerned a dispute over the ownership of lands that stem from the breakup of a Singapore family. The founder of I Ming Sdn Bhd or family company that owned the dispute lands was in a battle for control of the company with his first wife, who was supported by their children. The trigger of the family feud was the founder's intention to marry his second wife, Rahima, an employee who became the substantial shareholder and director of the family company. When the founder fled to Thailand and married Rahima, each side held various board meetings and annual extraordinary meetings to gain control of the family company. In the absence of the founder and Rahima, board meetings were held to first, remove the founder as managing director, second, appoint 3 new managing directors, third, declare Rahima's share certificates null and void, and last but not least, give the new managing directors the authority to sell the dispute properties and execute all relevant documents to give effect to any sale. Subsequently, the family company sold the dispute properties to Pekan Nanas Industries Sdn Bhd, or also known as purchaser. Let's look the judgment of the court. The founder and his wife, his second wife, succeeded in setting aside the sale in High Court. The High Court held that the purchaser couldn't rely on the Turquand'S rule, which was upheld by the Court of Appeal. Upon further appeal, the Federal Court held that the purchaser could rely on the Turquand'S rules because it is being an outsider who didn't have actual or constructive knowledge or means of discovering the irregularities had taken place in the internal management of the family company. That's all from me. I pass to my friend. Thank you.
Assalamualaikum and hi doctor. My name is Fahimul Azim bin Muhammad Anera. My metric number is 209368. Now I will continue the presentation with the exception to Turquand'S rule. Okay, first, the company are not bound by a forged document. For example, in the case of Ruben versus Great Finger Limited, the plaintiff was a transferee of the shared certificate issued under the seal of the defendant company. The certificate was issued by the company's secretary, who has forged the signature of the 2 directors of the company and had affixed the seal of the company. The plaintiff, in this case, had contend that whether the signature was forged or genuine comes under the purview of the internal management of the company. Therefore, the company shall be held liable for the same, but it was held by the court that the Turquand'S rule had never extended to cover the forgery. Lord Leburn had interpreted that outsider dealing with companies are not bound to inquire into their indoor management and will not be affected by any irregularities of which they are unaware of. Okay, next, the exception to Turquand rules. Turquand rules not apply to cases where third party is suspicious about the company. For example, in the case of Anand Bihari Lal versus Dinshaw and Co., the plaintiff had accepted that transfer of the company's property from the accountant of the company. It was held by the court that the transfer is void in nature, as such as transaction was beyond the scope of the accountant's authority. It was the duty of the plaintiff to check the power of attorney that was executed in favor of the accountant by the company. Next, conflict with public document outsider cannot claim that A, who's supposed to sign the contract on behalf of the company, had apparent authority in cases where it is contrary to public document. For example, in the case of Credit Bank Castle versus Schenkers Limited, the branch manager of the company had endorsed a few bills of exchange in the name of the company in favor of a payee to whom he was personally indebted. The company did not give him any authority to do so. It was held by the court that the company was not bound. Additionally, it was also stated that if the officer of the company commits fraud under his apparent authority on behalf of the company, then the company will be held liable for the act of fraud committed by the officer. Okay, lastly, insider of company cannot rely on Turquand'S rule. For example, in the case of TR Pratt Bombay Limited versus ED Session & Co Limited, Company A had lent money to Company B for mortgaging its assets. The procedure for the same which was laid down in the articles for such nature of transactions were not complied with. The directors of both the companies were the same. It was held by the court that the lender was aware of such an irregularity and hence the transaction was not binding. Okay, that's all from me. We continue to the next presenter. Thank you.